Good afternoon, everyone. My name is Rick Speck. I'm the Community Engagement Specialist for Safe and Just Michigan. We'd like to welcome and thank you for joining us for our Zoom conference titled The Evidence-Based Case for Ending Sex Offender Registries. Everyone at Safe and Just Michigan is thrilled you are participating. We have muted your microphones, however, to ensure that everyone can hear the panel. But please ask any questions you have using the chat function on Zoom. You will find that chat function on the taskbar when you hover your mouse over the bottom of the screen. For anyone who has not used Zoom before, the chat button is the one that looks like the talk balloon. At the end of the panel, we will gather up and answer questions for as long as time allows. We will be putting links into the to an exit survey and ways to get in contact with us on the screen at the end of the panel discussion. But you will also be able to find those links during the event in the chat room. For those of you who want to revisit this discussion, we are streaming this event on Safe and Just Michigan's Facebook page through Facebook Live, and it will be put on the Safe and Just Michigan YouTube channel later. You can also engage us on our social media channels or visit our website. I'd like now to turn it over to my colleague, Josh.
Thanks, Rick. My name is Joshua Hope, and I'm a policy analyst at Safe and Just Michigan. We put this panel together to discuss the state of sex offender registries in the United States and in Michigan. We are thrilled to have three experts to help us discuss this topic. Miriam Aukerman is a senior staff attorney at the ACLU of Michigan. She was the lead attorney in both Does versus Snyder cases, which went up to the Sixth Circuit Court of Appeals, as well as the more recent class action case, often referred to as Does 2. Vincent Schiraldi is a senior research scientist at the Columbia University School of Social Work, the co-director of the Columbia Justice Lab, and an expert in correctional supervision. He is a leader of the group EXIT, or Executives Transforming Probation and Parole. Judith Levine is a journalist and author. She's the co-founder of the National Writers Union and co-author of the new book, The Feminist and the Sex Offender, Confronting Sexual Harm and Ending State Violence. Before we start, I just want to say that we all know this can be an emotional topic. Everyone who has been impacted by these kind of crimes has every right to feel whatever they want to feel and however they want to feel. We're just having a good discussion, hopefully. Now, welcome to our panel. Let me start with Miriam Aukerman, who is the lead attorney in one of the biggest court battles surrounding sex offender registration, Does versus Snyder. Miriam, over the last several years, we've seen a number of legal victories, both in Michigan and across the country. Many of them seem to start with the difference between the early Alaska registry, which the US Supreme Court declared constitutional, and more modern registry designs. Can you fill people in on this history?
Sure, and Josh, thank you so much for having me. It's really great to be part of this really important conversation, and welcome to everyone who's participating. So really the history of litigation around sex offender registration in the last decade or so has been that we've been confined by the Smith v. Doe decision from 2003 by the US Supreme Court. And basically what the court there said is that that registration is not punishment. It's a complete legal fiction. The idea that, I think when you talk to registrants, when you talk to judges, when you talk to the public, when you see people talk in the media, they'll say this person was sentenced to, 10 years and sex offender registration. I think people think about the registry as a punishment, as something people get that they deserve as a result of their crime. But the legal fiction is that it's not in fact punishment. The idea is that it is regulation for the protection of the public. And constitutionally, what you can do when you punish someone is very different than what you can do in terms of regulation. And so the Supreme Court said in 2003, this is just simply regulation. And therefore it's fine because there's this high risk and therefore people, in terms of public safety, we can have these kinds of restrictions and apply them retroactively to people who were convicted of offenses a long time ago. What happened after that is essentially legislatures treated that decision as a blank check. And essentially said, we can impose whatever restrictions we want on people who've committed sex offenses. And that's still just regulation, and it doesn't matter. And those restrictions became more and more onerous, what we call super registration statutes, restricting where people can live, where they can work, where they can spend time with their children, requiring them to immediately report in person for even the most minute changes in their personal information, really just imposing these very draconian restrictions that that made this fiction even less true than it was to begin with. And so what we did in the Doe's litigation, what other attorneys have been doing as well, is really to challenge this idea that registration is not punishment by looking at how much more punitive the law has become, these laws have become since the 2003 Doe decision.
One of the real challenges for people on the registry is understanding and meeting the extensive registry requirements, which usually come with very steep penalties for non-compliance. Before you got to the Sixth Circuit, when you were dealing with Judge Cleland, he seemed to feel that the Michigan registry had some issues with vagueness. Can you talk about that a little?
Sure, and I think, you know, even the Sixth Circuit itself said that this is, they called it a Byzantine code. I mean, if you look at this statute, I've been working with this statute for, 15 years, and there are parts of it I don't understand. It is incredibly complicated, very specific, pages and pages and pages of regulation. It's very difficult for people to know what they can and can't do. One of the things that we did in the litigation was we actually asked, we had a number of people in our office call different prosecutors and police departments and ask them essentially the same series of questions. Can I go, if you're on the registry, can you go pick up your kid at school? How often do you have to, if you're using a vehicle, can you use it 5 times, 10 times before you have to report it? Those kinds of things. We ask, dozens of police departments, dozens of prosecutors got dozens of different answers. And when law enforcement itself and when registrants don't know what they're required to do, that law is unconstitutionally vague. So there were 2 very important parts of the decision by the district court judge that have not maybe gotten as much attention as the ex post facto rulings of the Sixth Circuit that I think are very critical in terms of the way that we think about registration. One is the idea that you can't punish people if they can't understand the law they're supposed to follow. And so what Judge Cleland said is you can't have strict liability. Strict liability basically says it doesn't matter if you understand the law, you're still held responsible for complying with it. It doesn't matter if you have what they call mens rea, a guilty mind and intent to violate the law. And so the judge said you cannot have strict liability. This is actually a very important part of that decision. It's now been applied class-wide in the Doe's 2 decision, and it will help to protect people who are trying to comply with the law, but somehow, make a mistake, get it wrong, don't understand what their many, many complicated obligations are. The second part of the vagueness analysis, which I think is also really critical and important for people to understand, is that Michigan, like many states, has zones, geographic exclusion zones that prevent people. In Michigan, it's preventing people from living, working, or spending time with their children within, it's called loitering, within 1,000 feet of a school property. But nobody really knows where those zones are. They're not painted. There's not like a line that, is painted around in the environment that you can go see, okay, I'm inside a zone, I'm not inside a zone. And what the judge said is you can't punish people for being inside a zone if you don't tell people where those zones are. And that is a really important legal principle because it will protect people who don't know where they can live, work, or spend time with their children. So those are the sort of 2 core principles from the district court judge that were then applied class-wide and that I think are important for litigation around the country.
And just to finish out the kind of legal analysis, the Sixth Circuit reached on different grounds. You made a little bit of reference to it. Is there a kind of quick way you could explain what they decided on?
Sure. So the Sixth Circuit made its decision on ex post facto grounds. So the ex post facto clause prevents retroactive punishment. Basically, if you're convicted of something, you can be punished for it, but then you can't change the punishment down the road. And the court said, and this was, what was really sort of very very important legal decision because it's the first federal court of appeals to do so. There have been some state courts that have done so previously. But basically what the Court of Appeals said is that Michigan's registration statute had become so extensive and so onerous that it is punishment. And it also said, and this really goes to the topic of today's discussion, that the registry was ineffective. Regulation is supposed to be tied to a non-punitive purpose, and the court essentially said this registry is so ineffective that it's unconstitutional, and therefore you can't say it's regulation, it's punishment, and you can't punish people retroactively.
Vincent, we were just talking about registration requirements, and I was so excited to have you on this panel because you're an expert in probation and parole kind of requirements. These have always seemed very similar to me. You being an expert in this, what do you see as the similarities and differences between registration and supervision?
So, but first of all, I want to say that was fascinating, Miriam. I really appreciate what you just said. Just hearing the way you presented it kind of blows my mind, and I found a million analogies to just the overall world of mass supervision, mass surveillance we're in. And, with some portions of it, electronic monitoring, house arrest, intensive supervision, probation, and registries being the deepest end of a very wide net and a wide problem. But there are 4.5 million people on probation and parole now, and that doesn't include everybody on the registry. That doesn't include everybody who's being supervised on pretrial release or out on bail or otherwise in the maw of the system. And I think it's grossly understudied, grossly under-advocated, grossly under-researched, grossly under-philanthropized and litigated. When Miriam was talking, it brought me to mind of a paper that a law professor at Yale has done, Fiona Doherty, called Obey All Laws and Be Good. And then there's a colon and a bunch of more words, but I'm sure if you look up Obey All Laws and Be Good and Fiona Doherty's name, you'll see it. And Fiona kind of gradually takes us through all the myriad ways that we've kind of created this caste of people who are less free than the average citizen, that the average citizen has no idea about all this heightened level of obedience and heightened level of goodness required of a certain class of people that in many ways, shapes, or form has no attachment to public safety, has no attachment to research. That's kind of this moralistic code that we foist onto people, whether it does or does not positively impact public safety, whether it is or is not really constitutionally tested, whether there's any research attached to it. So the world of probation and parole it exists in that space. It's 4.5 million people is more people than live in most states. It's double the number of people in prison and jail. And it doesn't even include, like I said, many, many people on the registry. This was a nightmare for probation commissioners. I know it's a nightmare for people on the registry. What most people don't get is it's a nightmare for people running systems as well, if they're human beings and thinking, if they haven't completely depersonalized the people they're supervising. Some have, many haven't, and they find it incredibly objectionable. One last point before you ask me your next question is, when we go to bars, we probation commissioners, we elect, when we're talking to elected officials about this, there's widespread disdain for these laws, and no one is willing to step out. And that is always a scary prospect. It's always a scary prospect to me when a big part of your leadership thinks a thing is stupid. That was true with the drug law mandatories. That's true with sex offender registries, but they're too afraid to say it. That's very, to me, McCarthyistic. And I very much feel that way about sex offender registries. I think that if you really got in a room and locked the doors and threw everybody's phones away and had conversations with many, many policymakers, they would say maybe this many people need to be heavily scrutinized, and a ton of the other ones, we are just doing it because we're afraid to publicly say it's a bad idea.
So research shows that both nationally and in Michigan, over 70% of people are generally put on tier 3 of the registry, which is lifetime. My working theory has been that the longer supervision lasts, the less successful it will be. Is that fair at all? Is there any truth to that in what you've learned from supervision?
Yeah, I mean, the overwhelming majority of the times people screw up after they've been convicted of a crime, it's like the first year or two. Everything beyond that is dramatically waning return on investment, if you will. And so many states are cutting the amount of time that people are on probation or parole. And then even when they cut it, they're giving people the opportunity to earn more time off for good behavior. So that's true in dozens of states, Louisiana, Missouri, Mississippi, Alaska. It's not just true in blue states. Many red states are allowing you to earn a month off probation for every month you don't get a revocation, but also are shortening times overall. And Pew Charitable Trust, the Harvard Kennedy School Executive Session, many organizations. The organization I co-chair, Exit, which is made up of 85 probation and parole commissioners, all have suggested that we shorten supervision terms, and even once we've shortened them, still allow people to earn time off so that there's an incentive, so that the only thing probation officers and parole officers have isn't just a stick, there's a carrot.
And I just wanted to interrupt. Vince, you have a high-pitched sound in your microphone. Actually, the sound is on with me too, and people are complaining about it. Maybe something, I can hear it now too, so I don't know what's going on with the...
Is there a way I can call into this and mute myself?
You can just mute, you can just mute your phone, but I'm also here. If everyone should mute at the same time. Josh, maybe if you mute too when you're not speaking.
No, I think it's a problem with my thing as well, though. So I'm gonna stop talking now. You can ask somebody else a question. I'm gonna try to mute myself on this and call in on my phone. Does that sound
Okay.
good?
Judith, in your new book, The Feminist and the Sex Offender, you argue that there's no logical reason for the continuation of registries. You make your basic case against the registry.
Yes, there is no logical reason, but as we know, laws about sex have nothing to do with logic. They have everything to do with emotion. Our argument about not just the sex offender registry, but all of the draconian laws that people with sex convictions are subject to extra long sentences, civil commitment, which is putting someone into a psychiatric facility after they've finished their prison term, to prevent them from doing a crime that they have not yet done. It's preventive detention. That this entire regime does not protect anyone. It has been shown not to increase public safety or the safety of children or the well-being of families at all. And that we now have enormous amount of research that substantiates that. And at the same time, it harms people. It harms people on the registry, their families, their friends, work colleagues. And I think it also harms our communities in that it is one of the things that makes us always suspicious of one another. You know, this guy, what's wrong with this guy? We also make a feminist case for this, which is that we cannot get justice for some people. We cannot, by doing injustice to other people. The sex offender registry and the sex offense regime, legal regime, is actually predicated on the same kinds of emotional and ideological things that rape is predicated on. That is that might makes right, that we should do more violence to people, and that's going to keep people in their place, or it's going to stop people from doing more violence. The state is doing violence to people, and that is the wrong response to violence that has been done by individuals to other individuals.
I think this is what you talk about when you talk about the split between what you call carceral and anti-carceral feminists. Can you explain the differences and how this brought you kind of full circle to opposing the registry?
The carceral approach is what we used to call law and order. It's an approach that says if there's a social problem, if somebody has done wrong, the best way to approach it is to punish it, to criminalize it and to punish it. And so the war on drugs was a very good example of a terrible policy, global policy, that was trying to address a social problem, an individual problem of addiction to drugs. So that's the idea. The idea of carceral feminism is that all feminists, and we hope all people, recognize that there is way, way too much sexual violence and domestic violence, violence against children, violence against women, and also violence against men and other people. But the carceral feminist response to this is put them in jail and keep them there. And if they come out, put them somewhere else. And if not, put an ankle bracelet on them and follow them around for the next 10, 20, 15 years, whole life. A feminist response is that, and this is a response that has come mostly from women of color, many of whom were themselves victims of sexual violence. And what they say is that the sex offender registry, like the entire criminal legal system, disproportionately hurts communities of color. It disproportionately hurts people who are poor, can't afford a good lawyer, and that that people who care about the injustices in our criminal legal system must also care about interpersonal violence. And people who care about interpersonal violence must also care about the violence that the state does to people, families, and communities.
So this panel isn't really about me, but I've pretty consistently made a simple evidence-based case against the registry. First, research has shown that public registries have been shown to increase recidivism. Not surprisingly, making people radically insecure, making it hard for them to find employment, housing, or maintain social connections isn't great for public safety. The reasons we have registry is supposedly based on public safety, but the evidence suggests that registration makes us less safe. Second, people on registries are often the least likely people to commit new sex crimes. The overwhelming number of new sex crimes are committed by friends and family members, and most are also committed by first-time offenders. This allows for people to have a false sense of security and ensures that our prevention and protection resources are spent inefficiently. Third, I don't really believe in registries, but if it were possible to have a good registry, that registry would always be the smallest possible registry. Currently, we have over 900,000 people on registries nationwide. And like I said earlier, 70% of people required to register are forced to register for life, which means registries will continue to grow and never shrink. Fourth, none of the current requirements, especially the registration requirements, are evidence-based. There was a sex panic, legislators responded, and now decades later, the evidence demonstrates there was not much of a reason for it to exist in the first place. Finally, these schemes are decidedly unsafe for anyone who's forced to register. Just last week, we had vigilante killing of someone who was on the registry. A few months ago, I personally was the target of a phishing scam, which was only possible because my information was publicly available. I suspect every person on the registry has some story of being harassed. I don't know if we've got Vincent back, but I hope we do. In all your years of looking at recidivism statistics and supervision, what have you concluded about what is most likely to keep people on the straight and narrow and what seems most likely to fail? Is there a better way?
Yeah, I mean, and to start with, as you said, the recidivism data for people who have committed sex offenses is no higher and often lower than a bunch of other people. The decision to pick them out has much more to do with sexual mores than it does with a sober and evidence-based assessment of safety, even if they worked, which they don't. And so, you know, the stories that, I want to tell you one story of like I used to every once in a while go to these conferences of other probation commissioners. And when the sex registry came up, I remember one suburban New York County probation commissioner talking about how this was playing out in his county. And the law in the county was, or the law in the state could have been, you can't live within 1,000 feet of a school, public housing, or park. And so several of the small communities in the suburban area started to name every blade of grass after somebody and call it a park. There was virtually no place to live in a bunch of small towns. So now you take folks that come from those towns, it means they can't live in that town and they have to live someplace. But because they're on a registry, everybody can go online and look at their dots on a computer. So nobody wants them living in their town. So then the probation commissioner, who's now involved in this, he's got to figure out what to do, right? Where to put folks, starts to rent rooms or get them to rent rooms in hotels, little motels that are, dotted throughout the county, most of which were used for one-night stands for teenagers in high school, right? And so then a law gets passed that if you have somebody who's in your hotel, who's on the registry, you have to put a sign on the front desk saying, in room 14B is a registered sex offender. So all the motels kick all the folks out that are on the registry because nobody wants that sign on their front desk. Ultimately, what the probation commissioner had to do was work with the sheriff to get space on the grounds of the jail, not inside the fence, but on the grounds, where they put a bunch of trailers so folks could live in those trailers. Now, unless you're independently wealthy and just don't have to work and just, have a car, I mean, there's just a whole bunch of, civil libertarian problems, but also public safety and recidivism problems. All of a sudden, you got a bunch of people in the same place. They may or may not have the same risk levels. They may be doing things to each other and with each other you don't want them to do. I mean, aside from just the horror of that story, if all you cared about was public safety and you didn't care one jot about dignity and people's rights as citizens, even then, it's lousy public policy. Doubly so when you actually care about your fellow human beings.
Miriam, your team during the Doe's versus Snyder decision and many allies worked to present a pretty comprehensive picture of the evidence about recidivism and risk. Can you summarize what you presented and what the Sixth Circuit's Court of Appeal had to say about risk after reading all the evidence?
So I'll say that one of the things that we did in the Doe's litigation was really put together an incredibly comprehensive record. And I say this whenever I do these kinds of talks, that this litigation is not easy. It's not something people should take on lightly, because it was really the really comprehensive record and evidence that we were able to put together over years of litigation in the Doe's case that convinced the Sixth Circuit that this is punishment. We did something like 25 depositions. We had, I think, 7 expert reports. And when you think about the expert evidence, I think there's a couple of ways to think about it. One is really thinking about what is the evidence on risk, and the other is what is the evidence on the effectiveness of registries. And I think a lot of times people focus on the evidence of risk, and really it's regardless of what risk is, registries don't actually work. And so I think that's really in some ways the much more important part of the research. What the Sixth Circuit said, and I'll just read you a little quote out of it, the record gives a thorough accounting of the significant doubt cast by recent empirical studies on the pronouncement in Smith that the risk of recidivism posed by sex offenders is frightening and high. Even more troubling is evidence in the record supporting a finding that offense-based public registration has at best no impact on recidivism, and in fact may increase the risk of recidivism, probably because they exacerbate risk factors for recidivism by making it hard for registrants to get and keep a job, find housing, and reintegrate into their communities. Tellingly, nothing the parties have pointed to in the record suggests that residential restrictions have any beneficial effects on recidivism rates. So basically what the court said was, looking at the evidence, there's just no evidence that these types of restrictions work, and that's why they're punishment rather than regulation.
And you said that the second part of that is the important part, which is that there's not a lot of evidence that registries work. Do you want to talk just a little bit more about that?
Well, I think there's a lot of discussion sometimes within these conversations about, recidivism rates being really low. And I think what often happens in those conversations is that you know, I think we also really have to, we have to recognize, and Judith talked about this as well, that there is incredible real harm from sexual offending, and that our goal here has to be to eliminate sexual offending. And for someone who is a victim or survivor of that, or is a parent who's concerned about their kid, any level is too high, right? And we really have to recognize that. The question is, how do we effectively deal with the very real problem of sexual offending? And registries don't do that. And so I think it's, from my perspective as an advocate, I think it's much more effective to focus on the ineffectiveness of registries than to have these debates about, you know, how often people recidivate, and is it, you know, do we, you know, is it 5%, is it more than, you know, like, and over what time period? I think those things go to how you would design a registry if you wanted to have a registry, and we think registries are really ineffective, although we recognize that there are real political considerations, and that you know, that there are realistic political considerations here. And so these lifetime registration terms make absolutely no sense. And even lengthy registries, you know, even 10 or 15-year registration terms make absolutely no sense. But I think the thing that we have to keep communicating to the public and to legislators is that registries are really counterproductive. And I also think that we need to think about survivors of sexual assault and violence as really our allies in this, and try to work to bridge those conversations, because we cannot minimize the harm that happens with sexual offending, but we have to say this is not the way to prevent that. We need to take these resources, these massive resources that are being poured into this ineffective, counterproductive system, and invest those resources into prevention programs, bystander programs, treatment programs, survivor support programs, to really recognize that I think all of us share the same goal here, which is a safer world in which every human being counts. We shouldn't be throwing obstacles in the way of every productive thing that people want to do when they want to reintegrate into society. But we also have to recognize that you know, that everyone needs a place, and that we really have to work against the harm that happens to registrants and that happens to survivors.
I think that's a really good lead in to kind of the hearts and minds kind of questions. If you were having a discussion with someone who identifies, say, as a carceral feminist, or someone who is a victim of a sexual crime, or really just anyone who opposes the registry because sex crimes largely do harm to women, how would you have that conversation? You know, kind of similar to what Miriam was just saying.
Thank you, Miriam, for saying so strongly for us to recognize and address violence, and I would say every kind of violence. I do want to just interject here that from our point of view, the people in this room and the 253 people who are watching now, it is really important not to say, well, some people should be on the registry and they're the worst of the worst, and we really need to supervise some people, blah, blah, blah. We have to abolish the sex offender registry, period. Because there are always going to be people who are the worst of the worst. They say that about civil commitment. I personally know people in civil commitment who had consensual sex when they were 19 with a 15-year-old person, or they downloaded child pornography, which could be a picture of a teenager having sex. And so the worst of the worst is always going to be subjective, and it will always be defined by somebody who wants to put more people behind bars. Okay. How do we talk to people about the relationship between these laws and dealing with sexual violence? One thing that I think we really need to talk about that we never do is that the things that we're punishing with the sex offender registry and with our laws have broadened, have increased more and more over the decades. So on one hand, it's really important to see that, for instance, sexual harassment is a really bad thing. It ruins people's lives. At the same time, we criminalize more and more flashing, let's say, or stuff that is hands-off offenses. We have increased the criminal penalties. We have mandatory minima for these kinds of things. And so there is a punitive atmosphere around sex, a fearful and punitive atmosphere around sex, and particularly around what some call deviant sex. And I'm not talking about sex that harms someone. I'm talking about consensual sex that doesn't harm somebody. So that atmosphere and that attitude towards sex is, I would say, at the heart of people's doing sexual harm to others. They don't know how to express themselves consensually. They don't know how to have pleasure. Haven't been brought up in homes that think of sex as a, you know, a pleasurable, happy thing that people do together. And so our entire culture around sex, you know, it sounds like a big thing to do, but I think we need to do it because we're not going to get rid of violence. But the other part, as I said before, is as long as we have a state that addresses everything it considers a social problem with violence, all the institutions in our country, everything in our culture is going to mimic, echo, reflect, and amplify that violent, punitive attitude toward problems that really need to be worked out between people, within families, within communities. The violent hand of the state. There's no way to start thinking about how do we express ourselves sexually in ways that will give pleasure and will not harm others.
I totally agree with that, and I just want to amplify it. By the way, this is a great panel discussion. I don't consider myself particularly an expert on this subject, and I'm learning an enormous amount from both of you, from all three of you. I think that you could say much of what Judith said about the sex offender registry writ large to mass incarceration and mass supervision. Essentially, we, over the last 4 decades, have created an environment in which more punishment, more regulation, more surveillance is the answer. Fill in the question. And so unless and until we grapple with that, I mean, you could really say, I see a lot of messages about abolishing the registry, and you could say the same thing about probation and parole, about community supervision, right? Like, I'm torn personally. I lean towards abolition of those things and to figure out a way to capture the savings and put it in the hands of community to help people thrive when they come out of incarceration in ways that communities would invent, that government bureaucrats will never in a million years invent. And I'm not trying to hijack the story to be about that. What I'm saying is, every time we tinker with this machinery, to borrow from the Supreme Court's, you know, sort of death penalty extreme statement, every time we tinker with this machinery, we validate it and only temporarily slow it down, if slow it down at all. Eventually, it's going to capture more of a market share. A, because that's what we bureaucrats want to do, right? We want a bigger market share. But B, because every time a case that isn't included occurs that falls just outside the guidelines, we move the guidelines. So if we say no consensual sex offenses below the age of 18, you know, the Romeo and Juliet stuff shall be on the registry, well, then something's going to happen that a 19-year-old does with a 17-year-old, and then we're going to, you know, so it just, these kinds of approaches that validate stupid practice that has no connection with rehabilitation, public safety, human decency, justice, just breathe life into, in my view, a bad practice that will figure out a way to grow.
It sounds like we've all
I
kind
want
of.
to also add to what Vince just said, which is that it's not happening to everybody equally either. There are certain communities, people of color, poor people, immigrant communities, that are under much more surveillance. They are hyper-policed. These are communities that have been underinvested in all of the good things that make people's lives good, like parks and schools and clinics and all of that. And they are overinvested in policing and surveillance. And so even when we talk about risk, one of the risk, so-called risk factors, is how many times you've been arrested for of a suspected sex crime. You don't have to have been convicted of it. Well, Black men are arrested a heck of a lot more than white men. standing in the wrong place at the wrong time, or the right place at the wrong time, and a cop doesn't like it. So there are differential impacts of our mass incarceration and our hyper policing and hyper surveillance. And so we can't just look at this as a kind of a blanket thing. We have to think about the ways that violence is done to particular people. And there is no greater prevalence of sexual violence among people of color than there is among white people. And yet, if you happen to live in a certain community where there are a lot of cops, you're much more likely to get arrested. And the other thing is police take your DNA, they take they do your biomarkers of your face. And in many states, they don't get rid of them. And so if you have been taken into the police department once, you're going to be taken in again, and you're going to be taken in again and again. So also what Vince says about tinkering around the edges, I totally agree that every time we do that, we legitimize the system. It's really a good system, but it just needs a little bit of tinkering, it needs to be reformed a little bit. No, it's a bad system, it's a bad idea. As you said, it's a stupid policy.
No, I mean, I think in this case, we have a policy, I think we get to this point a lot where, I mean, all of us seem to agree, but we keep coming across, this policy remains extremely popular despite decades of negative results. Do you all have any thoughts? And this is open to the whole panel, for how we change the narrative and change policy successfully, knowing what we know and coming to the conclusion we've come to. Anyone can start.
I think, this is the gist of it. And I think we should not be afraid to be radical. We should not be afraid to sound crazy. Ending mass incarceration, ending the death penalty, ending slavery, giving the vote to women, these were all completely radical ideas that most people opposed. And the discourse around mass incarceration has just changed a huge amount. If you have parole officers saying, we put too many people in prison, then you're making some progress. And so I think in this area, because people are so afraid of saying sex or the word child and the word sex in the same sentence, that we tend to hold back and not say what we really think and what we really feel. Because the more people, the radical edge pulls the more moderate edge, and not everybody has to be on the radical edge, but the radical, the discourse gets pulled in the right direction. So if we think there should be no sex offender registry, we have to say there should be no sex offender registry, period. If we think that everybody in Florida who has a felony conviction should get their right to vote back, we shouldn't say, except for sex offenders or people with homicide. Everybody who has a felony should get their vote back. And that, I think, really has to be our tactic. That has to be our both our emotional and our intellectual framework in the way we think about policy.
Miriam, did you have any thoughts here?
Yeah, I think we have a couple of things. I think we really need to reframe the narrative around this to be about the fact that registries sabotage every productive and useful thing that people try to do, and that they're counterproductive. I think we've often ceded the public safety ground and sort of and I think we need to claim that. We need to reclaim that space and say, look, these registries don't work, they're counterproductive. And so what they're doing is making our communities less safe by sabotaging every productive thing that people want to do and try to do when they reintegrate into their communities. I think we have to really acknowledge, and as I said this before, really acknowledge the reality of the harm that sexual offending causes, and make that a part of what we're talking about, and the fact that what we're trying to do is the same as what policymakers, what assault survivors want to do, which is preventing sexual violence. So I think we need to claim all of those things. The other thing I would say is, my experience on this is that when we started doing this work, we were very nervous about doing media and didn't do a lot of it. And now, actually, my experience has been that the media has really, come to understand that registries are very bloated. That, in Michigan, we have more people on the registry than we have in the city of, Muskegon. Most of you, if you're not from Michigan, you won't sort of understand those comparisons necessarily, but these are, I think we really need to have people recognize the harm, the size of the registry, who's on it, how bloated it is, and really think about using that conversation while acknowledging the harm that offending causes. So I think we really need to reclaim the narrative and shape it in our own terms, and not be scared to be talking about both the harm to registrants and the harm to survivors.
Vince, you've been part of a lot of big policies that have happened all over the country, not in this area, but in general. Did you have any thoughts here on changing hearts and minds?
Yeah, so I'm on June 17th, the Square One Project's gonna be putting out a paper that I'm writing on juvenile justice, youth justice reforms, and how there's been a 60% decline in the number of kids locked up in America, 70% decline in the number of kids in adult prisons and jails in America, kind of what a lot of adult criminal justice advocates are advocating for has already happened in the juvenile justice field. Not that I'm saying we're done, but it's a moment to sort of pause and say, had we get a 60% decline since its peak in 2000 to 2017, and what happened to adult system then that didn't happen in juvenile, right? So like a little lessons learned moment. And I don't pretend to be definitive on the lessons learned. That's the part where I just drew on my 40 years experience and pontificated. But I think one of the lessons was, first of all, kids are different and people view them as different. So yeah, we had a better playing field there for juvenile justice advocates. But I think part of it was we never fully allowed the dehumanization to stick. When John DiIulio and Hillary Clinton called kids super predators, there was a backlash. People fought that, right? And I think at the same time I was advocating on criminal justice issues as I was on youth justice issues. I feel like on the criminal justice issues, what we did was we listened to the bullshit polling that said, we need to talk about public safety. We need to be incremental. And so we didn't, while the right was fighting with Willie Horton and Richard Allen Davis and all these other horrible crimes that occurred, right? And polyclass and those kind of things, the left was talking about public safety and, not locking up nonviolent blah, blah, blahs. Whereas on the juvenile side, we're saying, whoa, 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 whoa. Yeah, this is bad policy. Yeah, this, yeah, that. But these are also human beings. These are human beings. These are kids. They're like your kids. And I think that we need to do a bit of that with this. I don't disagree with Miriam. I don't disagree with Judith. But I think the thing I would add is you can't dehumanize people until you depersonalize them first, right? If history's taught us anything. And I think we're never going to win unless we make people who have committed these crimes human beings. And that does not negate the human suffering, as I agree with I think Miriam said this, of people who've been victimized by sex crimes or any crimes, or as Judith said. But I think we're not going to be able to change policy unless we change the way people think about the human beings that are engaged in this. If I was in a room with $1,000 of yours, Josh, and it was on a bed and no one was around, I would not steal your $1,000. And partly that's because I think it's morally wrong.
Well, thank you.
That's because I think I might get caught and that would have repercussions for me. If I was in a room with a 9-year-old boy, I wouldn't have sex with that 9-year-old boy. Not because I'm afraid of getting caught or not because I think it's morally wrong. I actually don't have a desire to have sex with a 9-year-old boy. And that people that do have an issue we have to grapple with that's different than me stealing your $1,000. And they're still people though at the end of that. They're not subhuman because of that behavior. And I feel like we've let that go. And I think that we won't win the policy debate until we remind people that even when you do a really bad thing that some people find very disgusting, you're still a human being.
One other kind of thing that we've gotten sucked into, I think, as we move towards solutions, I think we've invested very heavily and I think successfully in court strategies, but lately we've started to see what I would call legislative circumventions. So the court passes something that seems pretty definitive. The legislature then passes something that really only kind of addresses it, but sounds good, sounds like it's trying to address it under the presumption that any new law is presumed constitutional. You want to talk a little bit about how this plays out, Miriam, and what your thoughts are on kind of navigating the legal and the legislative kind of minefields that we face?
Yeah, I mean, it's certainly a very complicated dynamic, and I've seen some questions in the chat about sort of the, legislative will and how do we get the legislature of Michigan to do the right thing. And I'll just, before I forget, encourage all of you from Michigan who want to get involved in the legislative effort to pass to have registry reform in Michigan, to get in touch with us. I personally can't handle all of those emails. I know people want to get in touch with me, but I can't talk to 44,000 people. So if you'd email intern, INTERN, at ACLUMICH.org, we'll get you involved in the legislative effort in Michigan. I think what happens, right, is that courts basically say, look, what you've gone, a legislature, you've gone too far, right? You've taken that Smith v. Doe decision as a blank check, and now you have this punitive registry, and you can't do that, or you have this vague registry, and you can't do that. But they accept the basic premise, and this is where we're sort of stuck legally with Smith, that you can have first generation registration statutes. And so they say to the legislature, go back to the drawing board, pass something new, and then we'll take a look at it. And legislators don't understand how registries work. They don't understand that they're counterproductive. They're scared of the politics around this. And so then they go back. I don't know if I would call it circumvention, because I don't know that they're trying necessarily to get around a court decision as much as that they're trying to have as punitive a law, or as something that they think is going to be as publicly acceptable as possible, and they don't necessarily understand the legalities of it. They'll tell you, look, we want to have something that's constitutional, but basically we want to only scale this back as little as we can. I think so the courts are basically saying, legislature, you go take care of it, because it's not our job to write statutes, which is true, right? It's not the legislature's job to write statutes. And the legislatures are saying, well, we're going to go as far as the courts are going to allow us to go. And I think we really have to change. We have to have a two-pronged strategy, because the courts are very important in terms of protecting people's rights. But ultimately, these laws are going to be written in legislatures. And so we need to have a strong legislative strategy. We need to be working on public opinion, which means doing this kind of really reframing of these issues, talking to legislatures, sharing the research, getting out and having those meetings with your legislators about reform, whether it's in Michigan or whether it's elsewhere, because we have to change this narrative if we're going to get the legislative reform that we need to see.
Judith, I think a good place for us to kind of finish off, I think a lot of people ask the question, well, what are the alternatives? I think Miriam talked a little bit about this, but part of your vision seems to be moving beyond punishment-based solutions. I imagine anyone skeptical of reforming registries is asking how we could deal with sexual crimes that heal the harm that those crimes create. What do you see as the alternatives to punishment and surveillance, and why do you think they would work better than what we're doing now?
Yeah, thank you for that question. It's a really important one. And there was a question on the chat saying, how do we talk to survivors groups who say that the sex offender registry validates them as survivors? That's a good word, validate. Means we value those people and their experiences. One thing about the criminal legal system is that it's actually not necessarily doing what it's supposed to do. It's supposed to hold people accountable. Now, if you have ever been a criminal defendant or a lawyer for a criminal defendant, your job is to say, you didn't do it. Even if you did do it, and if you did it not so much, or wasn't really your fault, et cetera, et cetera. Less than, So you're not taking accountability for something you did. And there's no opportunity for you to do that within the system. The person, the survivor, the victim, often feels that the prosecutor is her lawyer. And she learns very, very quickly that the prosecutor is not her lawyer. the prosecutor wants her to testify, but it's really up to the state, the people who are doing this prosecution. And so her feelings, her needs, you know, they might be shunted off to the part of the court that has victim services, a good thing. But she never gets to say to this guy, you know, why did you do this to me, A? And B, this is how you have really, really hurt me. You have changed my life, and I want you to hear it. So there are other ways of doing it in which the person who has done the offense understands why he did it and really takes responsibility for it and makes amends to the person he did it to. He hears from that person gets to say what she feels and what she thinks. And she also gets a say in, you know, what she would like to happen. Now, some people want the guy to go to prison for 20 years. And now we have victim statements. And if you're an articulate victim, you may get a better sentence than if you're an inarticulate victim. So there are growing, both within and outside of the court systems, practices called restorative justice practices, and within the community, a more politicized version of that, which is called transformative justice. And what this means, these are conversations within the community between people who have done harm and people who have had harm done to them. We don't call them offenders and victims. To do precisely what I'm saying, which is to be able to sit down and say, this is what you've done. This is how you've harmed not just me, but my family, my community, my neighborhood. Why did you do it? What are you going to do about it? What are you thinking about it? And let's work out together some way to make, not only to make me, the survivor, whole, but also to be able to get to a point where we can re-embrace you into the community. Because as Brian Stevenson says, no one is identified as the worst thing that they've ever done. You're a human being, as Vince was saying, you have to come back in. And that is what happens to most people who go to prison. They do come back. So we have to think about that. So restorative practices are done. Sometimes the judge orders it as a kind of a diversion. Sometimes it's done pre-charge. Sometimes it's done as a condition of probation. But then there are many people in communities who feel that they don't trust the court system, that this is not really voluntary, that if your alternative is you're going to go to prison, if you don't do this thing, it's really, you don't really have much of a choice. And also that this process does not address the larger systemic, social, racial, economic questions that are the underlying, that are making it possible for people to do harm, and also that are even, I would say, condoning that kind of violence. So transformative justice is like restorative justice plus politics. It's saying, like, we have to not only talk about the thing that this guy did, we have to talk about what made it possible for him, what made it impossible for him to have a life, a peaceful, productive life. And so these are processes that happen within communities. They're not perfect. The community can be just as vengeful and just as vigilante as the courts can be. So we can't romanticize the community, but it's a different way of thinking about harm being done. It doesn't say crime, because crime is something that has been decided through legislative negotiation and with political considerations, and am I going to get reelected and all the rest of it. We might say, this thing that this person did, in my view, shouldn't be a crime. Let's talk about that. So there are other ways of doing this, and fortunately, I just got trained at the Red Hook Community Justice Center in Brooklyn, which is just a fantastic court. And the judge there refers 90% of his cases to the peacemaking circles, which are a restorative practice. And once it goes to the peacemaking circle, the court never hears about it again. Whatever decision is made by the community and with that person is the end of the story. So we have to recognize that the way we're doing it isn't working. The sex offender registry is not working. Mass incarceration is not working. Surveillance is not working. Over-policing is not working. None of these things is working. So we have to try something else. It's not going to work perfectly, but let's at least try it.
Thanks so much for that, Judith. And thank all of you for answering my questions. Before I get to the general Q&A, we have a special guest, Dr. David Burgess, who's the president of Michigan's chapter of ATSA. David, did you have a few questions for the panel?
Sure. Thanks a lot for having me on. I just really appreciate the various opinions and information that you guys have been able to provide. As you were doing your presentation, I was checking off question after question that I had that you've already really answered. But I did have a few things. So I represent Michigan ATSA. I've been a treatment provider for 27 years, providing treatment to folks that many of them are on the registry. As president, as a board member and president of Michigan ATSA, so ATSA is the Association for Treatment of Sexual Abusers. We're the Michigan chapter of that. We have various stakeholders, treatment providers, outpatient, inpatient treatment providers, policymakers, researchers that are on our board. And we represent some of the folks that are stakeholders in some of these issues, and quite a few of the treatment providers within the state of Michigan. As a board, basically, Judith's point of view of we need to say the radical thing on one end, I think we're probably a little bit more middle of the road. If there has to be a registry, a few policies that we support are in regard to any kind of tiering should be related to risk, and they should be meaningful tiers. The idea that 85% of the people on Michigan's registry are on the highest tier doesn't make any sense, doesn't help at all in that area. We advocate for removing residency restrictions and making a path to removal. And that's maybe where my first question is. If there is a registry, can the panelists talk a little bit about what do you see as appropriate ideas for that path towards removal? What should that look like in any legislation that might come through?
I think anyone could jump in on that one.
I'm answering because, instead of off the thief's hand, we should just off one finger. I don't want to legitimize the thing by saying there are, good ways to do it. So.
I mean, I think, I hear Judith's point, but I also think that when you're involved in legislative negotiation, you have to be realistic about what is and is not achievable. And I don't want people to come out of this conversation thinking that the only goal can be to end registries. I think we have to think about longer term and shorter term goals, and we have to recognize where the political realities are and where the judicial realities, the legal realities are right now. And the law allows for first generation type registration statutes. And so I think we have to really think about how do we use the momentum that we have in the courts? How do we use the momentum that we're gaining in the public understanding of the counterproductive, ineffective nature of registries to really scale back registration in the way that David is talking about? And I think that means, for us, there are a couple of big priorities. One is really dramatically shortening registration terms, ensuring that there are a lot of people who don't have to register in the first place. That would include children. That include people who don't have convictions, set-asides, expungement, those kinds of things. Lower level offenses, that those are not at all included. And that the terms for anybody who is on the registry are very short because if you look at desistance research, it shows that any kind of recidivism happens within a really very short time frame. So I think those are really important steps. I think there's a lot of, there's sort of a lot of back and forth about risk-based assessments and kind of the pros and cons of those. But I do think that we need to think about ways to have people individualized review and also really putting the burden on the state to say, so the burden is not on you to say, hey, I should come off, but really the burden is on the state to say, this person needs to stay on, and here's why. Because burdens are very important in a legal regime in terms of who has to prove it. And if the state is going to do this, if the state is going to say, we need to regulate you, we're not punishing you, by the way, but we need to regulate you because of potential danger, then they should really be able to show that there's a reason for that. And it really should be their burden to do that. So I think those are some of the principles that would guide the reform that we want to see. And, you know, I'm a lawyer. I'm not a policy analyst. I don't, this legislative, you know, horse trading is something that sort of goes against my sort of clear idea for principles. But I also think that we have to recognize that the registry is doing tremendous harm, and that we want to scale that back very dramatically if we can do so. And that is going to mean compromises.
So another question that I had kind of related to that, thoughts or opinions on a sex offender management board, what you've seen in other communities that helps to set policy with that. What are your opinions on that?
I've observed these boards. The ones I know best are in Texas, and they can be just completely corrupt. I mean, basically, you know, licensing people who are their pals. I mean, I think it just moves it slightly outside of the legislative realm. It's another part of a bureaucracy that already has enough bureaucracy. And often the sex offender management boards, first of all, I don't really like the word management, and I don't like the word sex offender either. I think we should stop calling people sex offenders, and we should stop calling people predators, another word we should never, ever utter.
In our groups, we call ourselves people forced to register. People forced to register.
Yeah, registered citizens, registrants, whatever we want to call them. You know, I don't know if these management boards, they're appointed by the legislature generally. So it all comes back to who the legislators are and what kind of experts they want and all the rest of it. I think one of the things it does do is, I think Miriam's point is very important, that, you know, we have to get things done in the real world. And, you know, I'm a radical politically. I think that we can have reform, and it's not one or the other, reform or radical change. When we are doing reforms, though, it's really important for us to look at each reform and say, is it walking us in the right direction, or is it something we're going to have to undo later? So reform to be seen toward an ideal. We have to know what we want in order to get there, and we also want to know, we have to know that, you know, this sounds good for now, but it's actually going to be worse. Like, for instance, there's proposals to have a police-only registration. That would be another thing we have to undo. Let's not make another thing that we have to get rid of. So the other thing I think we really do have to talk about with our representative from ATSA is the way in which the so-called treatment providers and the whole network and the whole function of treatment within the registry regime can be extremely punitive. It's way too long. A lot of people have terrible experiences. A lot of people have good experiences because they've never, ever had therapy. And they've never had the opportunity to think about themselves or their feelings or why they do things or why they've harmed people or their guilt or whatever it is. But a lot of sex offenders, it doesn't really help anybody. It's brainwashing. And if people fail, and that's up to the provider, they can be sent back to prison. That can be a violation of parole or of the registry. So it really does work hand in glove with the punishers. And I think it's a real problem. Everybody needs therapy, and probably a lot of people, everybody who comes out of prison probably needs therapy. It's a traumatic experience. But the idea that there is such a thing as a sex offender and that this is a diagnosis is really, there really is no single profile of a sex offender. So to be giving treatment for this supposed diagnosis in itself is problematic.
Well, I wasn't trying to start a war between the therapists and the panelists, but Miriam, did you have any thoughts on that one?
No, I think I'll pass on that. There was a question in the chat that I wanted to respond to, but let me continue.
Well, I'm about to go through the chat questions separately from this. David, thanks so much for helping with that and for joining us. Hopefully we'll have more discussions in the future.
I appreciate that. Judith, I'd love to have a conversation with you at some point as far as how treatment has changed significantly over time and where that's going nowadays.
Let's get in touch.
That's what I like to hear, people coming together to make change. So the first question was for me, and what was my point 3? I think I was saying that we need to remove more people from the registry than we add every year, that the smaller registry, the better. I think that was my third point. There was this question. I think we lost Vincent. He might have been the best person to answer this, but can the panel members speak to the uniqueness of restrictions on juveniles and young adults? And I think we're going kind of speed round, so if everyone can kind of give short, we got a lot of questions to get through in about 20 minutes.
I mean, there's the legal answer and there's the social science answer. The legal answer is that, and they're both really the same. It's totally outrageous to register children. And from a social science perspective, children's brains are not as developed, and they make impulsive decisions, and then they grow up. And anybody who's had children or ever been a child, which is all of us, know that. Putting people on lifetime registration or even the extended registration, shorter terms, for something that they did as a child is outrageous. And the law also recognizes that children are different, and so that's why you're seeing in a number of states now, state Supreme Courts finding a registration of children to be unconstitutional.
This is a good question for Miriam too. I'm fearful for my children and family in light of the recent Fairbanks case, and how long before the ACLU takes cases in other areas. I saw a couple questions like this where it was just questions about the ACLU in Michigan versus other areas of the country.
Yeah, I mean, I get that question a lot. Every ACLU is different. This is a personal passion of mine, something that I've been working on for about 15 years, coming really out of my work before the ACLU during reentry litigation. There are a number of ACLUs that are very active on this. There are others that are not. A lot of it is resource constraint driven. I don't have any particular pull to get other ACLUs involved in this, although it is something that I do talk to my colleagues about. But it's not like you can contact me and I can get the ACLU in your state to take something on. I guess, what I can encourage you to do is, to continue to reach out to try to have conversations with ACLU attorneys and advocates in your state. And those of us within the ACLU world who are litigating these issues are also trying to encourage our colleagues to take this on. It's hard, frankly, because especially with the coronavirus, there are a lot of demands on the ACLU on lots and lots of issues.
Another kind of legal question, is there any one place where registrants and their families, I kind of know some of the answer to this, can find the laws on the books to know what is required of them? I've been told to look at penal codes. Do you have any thoughts on that, Miriam?
Well, Josh, if you know the answer, tell me, because I think it's actually very difficult.
A lot of work, and you have to look a lot of places.
It's very, very difficult. I mean, even in Michigan, there's not like one place that you can go to find like all the requirements. You get an explanation of duties when you register, and it's largely like it's not particularly accurate or technically correct on a lot of sort of fine points of law. I encourage people when they ask me this to talk to the sex offender registration unit in whatever state it is, to talk to attorneys in that state, but there's not an easy way to find this out that I'm aware of. If there is, enlighten me, because I'd be very interested, Josh.
Yeah, I've seen people who've put, for instance, together long spreadsheets of all the different rules for just like You know, one of the things that you have to worry about when you're on the registry is how long you could be in another state before you have to register in that state. And so I've seen lists that people have compiled of that and things like that, but you really have to do detective work for every state, unfortunately. So a next question was that someone was suggesting that they are about to teach a college class. They were wondering if there's any good literature they could use for a general ed course. I think this would be good for, I can suggest one right now, which is The Feminist and the Sex Offender by Judith. Judith, did you have any other thoughts on that?
No, but Emily Horowitz has taught classes on, false accusation. She does a lot of stuff about sex offense. So if you just look for her. I think a really good thing if you are teaching a class like this, this is following up on what Vince said, is to invite people who are on the registry to come talk to your class. I really thank Josh for doing this. It's brave to do it. And talking about humanizing, here's a regular guy in a white shirt and a tie, smart guy, a human being on the registry. And I think that it's really important. I think that in the criminal legal system reform world, having people who were on death row, having people who had, 25, 30, 40-year sentences for a homicide that they did when they were 19, and here's a regular person who has a family, and it's hugely, hugely effective. And I think that you want your students to really get the texture of what these laws do. So in addition to the kind of, a good book that Emily wrote is called Protecting Our Children, with a question mark. It talks a lot, she did a lot of interviews with people in the registry, and she talks about the laws and the, there's a reason. She also did a debate on reason.com, which is very good. It was for and against the registry. And that would be very good to show your students, probably about an hour long. So I don't know, maybe Josh, we can talk about this later, but I do think that having actually people who have this experience, it's really, really educational.
Miriam, you look like you had something.
Yeah, I would just suggest there's a great article by Ira Ellman that I'm sure someone can find and put in the chat that debunks a lot of the science and really explains how the court decisions were based on pseudoscience. And I would encourage anyone to also look at the, the main Supreme Court decisions on this, and also, the Sixth Circuit decision or other recent decisions around the registry. To kind of, I always think not just lawyers should read Supreme Court and judicial decisions, because they're actually very influential. So that combination of the Ellman article and the Supreme Court decisions he critiques would be fascinating for students.
Yeah, we've been putting a lot of the links to the different court cases in the chat box throughout that I compiled in advance. Next question is, when is Michigan's legislature going to pass legislation to reform or abolish Michigan's registry? Well, we actually have been spending the last month essentially in hearings about what is called House Bill 5679. I testified, Miriam testified, a bunch of other people testified. A huge number of people in the registry testified, which I thought was really amazing and took a lot of courage. So my guess is we're going to hear something about that pretty soon. I can't give you an exact date, but I'm hopeful that all of our efforts have maybe delayed or changed what was going to be passed. We'll see. Do you have any thoughts about that, Miriam?
Yeah, it's a really, really terrible bill. It's just awful. So we're hoping that it will get substituted for something that is a bit more rational and, possibly even constitutional would be nice. And which is not, this bill is neither of those things. I will, again, encourage people to get involved in Michigan, intern at ACLU.mich.org. If you want to get involved in the legislative work, we really need people. This is really the time for registrants and advocates to step forward in our state. It's a critical time. Basically, the court has said that if the legislature doesn't pass new legislation, the registry will be void for pre-2011 registrants, which means that the legislature is feeling a great deal of pressure to act very quickly, which is good in some ways, but is also bad in the sense that they want to rush through something that's really bad. In the meantime, we have, and I meant to mention this earlier, we have a court order that suspends enforcement of Michigan's registry during the course of the pandemic, which is actually very important. We haven't really talked about the pandemic and its impact on people on the registry, but obviously if you're required to report in person for every little thing that happens in your life, as you are in Michigan, that's very difficult to do when you're supposed to abide by a stay-at-home order and socially distance. And so we have that order, which in Michigan, which a lot of people aren't aware of because we haven't, the state was not required to do notice as part of that. But what that order also does, it gives the legislature more time to pass something. So we're hoping that with that greater expansion of time, we'll be able to use to work with all of you, get you in to talk to legislators, to testify, to write letters, call your legislators to really try to pass something. It's going to have to be real world. It's not going to be the end of the registry, but to pass something that really scales back the number of people on the registry, the length of time people are on the registry, and also the number of people on the public registry, which is not something we've talked about a lot, but that is really one of the greatest sources of harm and is a major priority for us legislatively.
Judith, someone asked, what are some of the best examples of prevention programs for sexual crimes? I think you've covered some of that already.
I don't know about programs. You know, I think essentially not doing harm to others is an ethical and moral education question. The same things that, you know, you don't go and hit somebody who doesn't want you to hit them. You don't put your fingers into somebody who doesn't want your fingers. So I think that sex education, comprehensive sex education, that also talks about pleasure and what sex is about, relationships and all the rest of it. I really think that that's probably one of the best ways that we can prevent sexual violence. And I don't think that specifically talking about sexual violence, especially for little kids, they had this good touch, bad touch thing, which turned out to be just a nightmare. Kids didn't want like their aunt to pick them up, So both, being able to know what you want and being able to talk to other people and understand what they want, even in the most simple ways, sharing toys. That to me is the best way to prevent all kinds of violence.
Miriam, here's one for you. Could you please speak on the undue, in my opinion, deference that courts tend to give legislative intent in the relationship of cases? I think we talked a little bit about this already.
Yeah, I think we've talked about this some already, but basically courts are not supposed to write laws. They're supposed to interpret laws, and so they spend a lot of time trying to figure out what did the legislature intend, and they say that the legislative intent was not punitive, and therefore that makes the test more difficult legally. So courts do give a lot of deference to legislatures, both in interpreting whether a law is constitutional, and then in sort of saying, okay, well, it's not my job to rewrite the law, it's up to the legislature to rewrite it, which is where we get into this problem that Josh identified earlier, which is, courts will strike things down, but then it's up to the legislature to pass the new law. And because they're not going to just, like in Michigan, they're not going to just accept that everybody pre-2011 comes off the registry. The question is, what does that legislative rewrite look like? So there's both aspects of deference to the legislature.
Judith, I guess you'll get the last question before we turn it back over to Rick. Someone asked about the kind of relationship that is used to justify registries from people who have been harmed and people who have done harm, kind of the victim abuser dyad. Could you speak to that a little bit?
I'm not exactly sure can you say the question again?
The use of kind of victims to justify the registry, people who've been harmed.
Yeah. As I said before, and Vince was saying, if you have a hammer, everything looks like a nail. That if people who are survivors, first of all, the restorative justice, certainly the transformative justice movement in this country was started by a lot of people who were themselves survivors of sexual violence, who wanted something different. They recognized that mass incarceration was harming their brothers, their fathers, their husbands. And so a different kind of conversation that moves past vengeance. I mean, I think like sometimes if people who, I'm always very moved by people who like had a child who was murdered, and then many years later they go and they meet the person who murdered their child, or they knew him, or whatever it is, and they're able to move through that, a very, very, very difficult thing. And often what they say is the great weight was lifted from their own shoulders of hatred, of sadness, grief, anger, all of the rest of it. It's not up to me to tell people how they feel, or, I mean, I think we just have to listen to people about how they feel, what kinds of harms have happened to them. But I hope that being actually able to talk, confront, talk with other survivors, maybe not talk to the person. A lot of people don't ever want to see the person again, right? So there are prison programs where a survivor comes in and talks to people who are coming out of prison, and as a kind of surrogate, to say, this is what happened to me, and this, and you need to think about, you need to hear my voice. So I don't think that it's useful to applaud a sense of vengeance. I think we need a way for people to work through, have some amends made, real amends made for the very, very terrible harm that has happened to them. We have to hear their feelings and their hurt. And if there's only one way to redress that, which is to throw them in prison and put them on the registry, then that's all people have. We need to give people other alternatives to that.
Well, I want to thank both of you all for doing this, and I tried to ask every question I saw that hadn't been answered in the chat box already. So thanks to everybody who listened, and I'm going to turn it back over to my coworker Rick. Thanks, Rick.
Thanks a lot, Josh. Thanks to everyone. Safe and Just would like to thank everyone for participating in today's event. We're going to ask you to do us a favor and answer our exit survey to help inform on these. And on the screen, we have included several ways that you can keep in contact with Safe and Just Michigan. We look forward to connecting with you, and we ask that you keep an eye out. We'll be hosting an upcoming series of webinars on the Jails Task Force soon. So thanks again for participating. Thanks to the panelists, and have a great day.